Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video today, I'm not going to make a retraction exactly, but I'm going to qualify some things that I've said in other videos, especially those videos on this channel with respect to the O1 visa and the P visas, the so-called dual intent visa categories. I think this could even apply to things like the L1, although perhaps not with respect to something like the K1, and I'll get into that momentarily. It's recently come to it didn't come to my attention, but as with everything in immigration law, there's nuances to the statute, there's nuances within the Foreign Affairs Manual, there's nuances within how consular officers make adjudications. Quite honestly, it's been my experience that different posts, different embassies around the world make different determinations. I won't say they're contrary to law exactly, they just have different ways of interpreting how that law should operate, and they also have different ways of interpreting based on the given sets of facts that are given to them in the various nations in which they operate. This is somewhat, as an analogy, and maybe for those who are sort of legal scholars that are watching these videos, sort of as an analogy, I think it's analogous to, look, different states take a different position on different issues. Now, I don't think anyone can argue with the notion that over the years, especially in the last 100 years, American jurisprudence state by state has become increasingly more uniform due to various things. But that being said, there are still nuanced differences between the way different states have a take on different pieces of legislation, different laws, etc., or different issues for that matter. Most recently, for example, same-sex marriage. There were radically different views along a spectrum with respect, on a state-to-state spectrum, with respect to how same-sex marriage was viewed. To not digress any further, we're talking dual intent. Dual intent visas such as the O visa, the P visa, the L1 category, some others. The dual intent notion is you can maintain not only an intention to be a non-immigrant, but also to remain in the United States. Now, certain categories like the H-1B, this is much harder and fast. The K-1 is another one where it's a hard and fast intention. And in fact, with the K-1, you really do, at the time you're applying for the K-1 fiancé visa, need to actually intend to live in the United States, get married and live with one's fiancé, American citizen fiancé in the United States. This is a little different with like the O category, which is like, can be used for certain types of entertainers, show people, various types of sort of artists. These kinds of individuals or practitioners of their craft, whatever you want to call it, the O is not as hard and fast when it comes to dual intent. And what I mean to say is, it's still possible to apply Section 214B when it comes to such categories. And for those who are interested in the specifics of 214B, and I'll do a quick rundown, but I would strongly recommend going to, there's another video on this channel entitled 214B. There's a couple other videos with respect to 214B on this channel. I recommend checking those out because I think they're rather interesting, and they'll provide a little bit more nuances to what we're talking about. But essentially, as sort of an overview, 214B allows a consular officer to deny a non-immigrant visa if the applicant demonstrates weak ties to their home country and strong ties to the United States. That's essentially the analysis structure that's utilized. What are they going after? Well, they're basically looking at people who are going after a non-immigrant visa who actually have immigrant intent. Let's take the O visa, for example. I won't get too detailed because I like to keep these videos short. Thanks to your comments, I've been told it's better when I keep them short, so I'll adhere to that. Let's just take the O visa. The O visa, one can go over to the United States as, say, an actor or an actress utilizing an O visa, and one's long-term plans could be to stay in the United States, in theory. Now, that being said, and I've dealt with this sort of in a rather narrow context with a few clients over here, I always make sure to keep in mind, have those folks keep in mind that, look, you're only able to be in the United States for the duration of your visa and for the purpose of your visa. It's not a green card. But that being said, later on down the road, if one can show sort of a heightened level of how do I put it, sort of celebrity within, let's say, the acting community, or a heightened level of skill and ability with respect to one's given craft, it may be possible to apply for, a visa that's going to grant lawful permanent residence. Basically apply to remain in the United States as a landed immigrant, essentially. But that being said, you can maintain that sort of nebulously. And I don't know how nebulous any given individual is going to maintain that kind of intention. But that being said, there are instances where the consular officer can find, look, I think that this individual has immigrant intent, and for that reason I'm going to go ahead and deny based on Section 214B of the Immigration and Nationality Act. And as stated earlier, there's sort of a balancing test that needs to be done with respect to that. To be clear, and I'm not going to go into great detail, this is way more nuanced an analysis, especially with respect to the relevant sections of the Foreign Affairs Manual. This is a way more nuanced analysis when compared to, say, U.S. tourist visa applications in Section 214B, or U.S. student visa applications in Section 214B, as those are done on a much more routine basis. And I'll be candid, the reasons for denial are generally more routine. It's oftentimes immediately apparent that the person applying for a tourist visa probably has some level of immigrant intent in their heart, or heart of hearts, whatever you want to call it. So to sum this up, to nuance a prior video I've done on both the O and the P visa specifically, yes, there's dual intent involved. You can have this sort of nuanced notion of wanting to remain in the United States, but if a consular officer makes a decision that they in fact think that nuance or that nebulous nature is much harder, and that there really is an immigrant intent underlying the use of a non-immigrant visa, denial of one of these visas or one of these visa applications can occur based on Section 214B.